Welcome to the SKOCH India Law Forum and LITFest 2022, organized under the aegis of the 82nd SKOCH Summit. Today, we're joined by Sri Sameer Kochhar, author, reforms historian, and chairman of the SKOCH Group, and our panel of legal experts for this conference on the future of energy and arbitration. The 2021 United Nations Climate Change Conference spurred on a global commitment towards net zero. So we're looking at a massive effort to shift from fossil-based fuels to renewable energy and new energy sources like never before. This serves as the backdrop for our panel today to discuss energy law contracts and disputes arising from them and what it all means for the future of domestic and international arbitration. It's my pleasure to now introduce our panel to all of our viewers. We're starting with Mr. Jatinder Cheema, an energy and climate change lawyer and public policy expert. His legal expertise is vast, so for the purposes of today's conference, I'm going to highlight the work he's done in the energy sector. He currently serves on the US-India Gas Task Force, established by the US Department of Energy and the Indian Ministry of Petroleum and Natural Gas. He's also serving on the US-India Low Emission Gas Task Force under the US-India Strategic Energy Partnership. He also drafted the current Master Revenue Sharing Contract and related policy documents under the Hydrocarbon Exploration Licensing Policy. We have with us Justice R.V. Raveendran, former Judge, Supreme Court of India. He served as a judge of the Karnataka High Court, Chief Justice of the Madhya Pradesh High Court, and a judge of the Supreme Court. In this time, he's been a chairperson of many important committees like the Karnataka High Legal Services, the Karnataka State Legal Services Authority, the Supreme Court Legal Services Committee, and the Supreme Court Mediation and Conciliation Project Committee. He's been involved with arbitration and mediation even after his retirement in October 2011 and has served as the chairperson of the News Broadcasting Standards Authority from 2013 to 19. We have with us Mr. Jatin Jalundhwala, Joint President Legal of Adani Enterprises. Mr. Jalundhwala has worked with various regulatory authorities like the Ministry of Corporate Affairs, stock exchanges, RBI, and others on matters like arbitration, contracts and agreements, corporate governance, and compliance. He's been instrumental in drafting and implementing various internal policies regarding insider trading, whistleblowers, anti-corruption issues, codes of conduct, CSR, and more. We have with us Mr. Francis Xavier, partner international arbitration at Rajah and Tann, Singapore LLP. He's their regional head of disputes and practices cross-border commercial litigation and international and treaty arbitration. He's a leading disputes lawyer and was recently named as one of Asia's top 15 litigators in the Asian Legal Business 2021. He is a past global president of the Chartered Institute of Arbitrators and also past president of the Inter-Pacific Bar Association. We have with us Ms. Meenakshi Arora. She's a senior counsel practicing at the Supreme Court of India. In 2013, the full bench of the Supreme Court, headed by then Chief Justice of India, P. Sathasivam, recognized her as a senior counsel, and she holds the honor of being only the 5th ever woman to be designated the title. She was one of the members of the drafting committee which drafted the regulations on the gender sensitization and sexual harassment of women at the Supreme Court of India, Regulations 2013, to protect and provide grievance redressal to women lawyers from sexual harassment at the Supreme Court. We have Mr. Nakul Dewan, senior advocate of the Supreme Court of India. In the arbitration niche, he's appeared in a number of leading cases, both before the Indian Supreme Court and Singaporean courts. He's also been appointed as an arbitrator by SIAC, ICC, and LCIA for international commercial arbitrations, and by the Supreme Court of India and the High Court of Delhi for arbitration seated in India. And finally, we have Mr. Tariq Khan, who's currently the Registrar General of the International Arbitration and Mediation Center. He's a former partner of Adani & Co. New Delhi, which is one of the oldest law firm, which is the oldest law firm in India. He was featured in the Forbes Legal Power List for 2020-21 as one of the top individual lawyers. For 2020, he's also been recognized in Business World Legal 40 Under 40, and SEC Online credits him as an arbitration expert. He's authored several important works, including a commentary on Indian arbitration law. His specializations include domestic and international arbitration, commercial disputes, writs, MSME disputes, insolvency, and bankruptcy cases. I'm going to now invite Sameer Kochhar to declare the panel open and share a few words with us. Sir, over to you.
I'm muted.
Sir, you're muted. You're muted.
So I said namaskar and thank you, Brindaji. I will literally say a very few words because my field is not law, my field is economy. And the lesser said, the better about it is good today, you know. We are not in a very good place. And the reason for not being in a good place is energy. It's the oil prices, it's the coal shortages, and, you know, a very, very uncertain future globally that faces us all. And for India to be coming out of the COVID and, you know, growing at the rate it needs to grow, energy self-sufficiency is extremely important. Capital as it is not being formed, investments are not coming, and efficiency of capital utilization is extremely important. And one of the stumbling blocks in that, which causes time and cost delays, is arbitration, of course. How do we speed that up? What can be done about it? So I am hereafter only here to listen as to if all you good gentlemen talk, when you talk about future of energy and arbitration, would you be able to give me a few economic clues as well, which then I can write about or go back to the government with. With that, I would leave you in very able hands of Mr. J. Cheema, my friend and senior advocate.
Thank you, Brinda. Thank you, Mr. Kochhar. Thank you, Rohan, for organizing and putting this evening together. Welcome to Honorable Mr. Justice Raveendran and all my colleagues from the bar and the industry. This event has brought together legal luminaries and professionals for an engagement on a cutting-edge subject in the industry impacting the dispute resolution community. Post COP26, the focus on energy transition and the path to net zero has been intensified. This session will focus on global energy transition from fossil-based fuels to renewable and new energy sources and its implications on the future of international and domestic arbitration. In the recent years, arbitration has created a niche for itself in the world of dispute resolution and is now the most favored method, especially for resolving energy disputes. Energy projects are usually long, complex, and require a substantial level of capital investment. The energy projects are generally high in value. Small errors can lead to loss of business entities running into few million or sometimes billions of dollars. Additionally, the sector has significant exposure to geological events, political changes, and environmental regulations. For these reasons, disputes are common in the energy sector, and arbitration is fast becoming a preferred method of resolving these disputes, particularly at the international level. Since arbitration is a creature of the contract, it permits the parties to design a level playing field, also catering to complex nature of disputes. Disputes may occur in all energy sectors, including biomass, coal, energy efficiency, which is construction and transportation, LNG, hydrogen, geothermal power, hydropower, nuclear, oil and gas, solar energy, wind energy, offshore wind, and often related to research, testing, certification, generation, conversion, transportation, transmission, manufacturing, distribution, or consumption activities. The disputes arising out of energy law contracts are in stark contrast to the regular contractual disputes. The intricate sophistication and the design of the contracts in the energy law domain remains unparalleled. Legal and regulatory risks in the energy sector is already a complex matrix involving global players and is further complicated by the fact that there is no single universal legal system. There is a plethora of different and often conflicting systems across the globe, and as dispute arises, multiple courts, tribunals shall grapple with, and laws will evolve or be legislated to address challenges created by fast emerging new business realities. Any dispute that concerns the generation of the source of power qualifies as an energy dispute. with onset of rapid development in the energy sector, there has been a great need for arbitration to be used as a mechanism for resolving disputes. This will result in saving costs incurred, granting flexibility in adoption of decision-making procedures, further would help in taking speedy decisions, diminishing the risks suffered. Arbitration as a mechanism will also protect the privacy of party entity. Energy disputes may fall into different categories depending on the parties involved. Two major categories, however, commonly seen are disputes between states, which means state entities, and private parties, the dispute between two private parties. Majority of the disputes in the energy sector pertain to supply agreements, quality of the product, quantity of the hydrocarbons, transportation, storage of hydrocarbons, pipelines, engineering, construction, international boundaries between states, especially in offshore fields, joint venture, joint operating agreements, and with respect to environment, such as oil spills and nuclear power plant disasters. Defects and late completion of low carbon renewable energy projects are generating a large number of disputes, such as price review, supply, transportation, storage, decommissioning, and asset retirement obligations are expected to continue to dominate the disputes claim. Given the complex and peculiar nature of disputes in the energy domain, it is pertinent that tribunals comprise of technical and judicial members to strike a balance between the specialized and legal aspects of the dispute. With the claims falling in both technical and legal domains, it is imperative that the tribunal must be equipped with domain expertise. Further, the need for testimonies for expert witnesses is inherent for effective adjudication of energy disputes. As per the emerging trends, international commercial courts are gaining ground and would be a viable alternative to arbitration as means of dispute resolution. International commercial courts are well suited for using traveling judges because of international character of many commercial disputes and the shared legal heritage between various civil and common law jurisdictions. Traveling judges and counsel have enriched the jurisprudence of courts, such as that of the Court of Dubai International Financial Center, DIFC, as they bring legal knowledge from broad range of jurisdictions. The DIFC court, for example, has considered questions related to public policy exception to enforcement of arbitral awards and whether a civil or common law approach would apply to such questions. Further, recently, the release of the report of International Center for Energy Arbitration has sparked a debate over inclusion of sanctions within institutional rules to encourage parties to comply with pre-action procedures and over-enhance confidentiality and anonymity offered by regimes such as that operating under the Arbitration Act 2010 of Scotland, where confidentiality is actionable and court proceedings are anonymized. Thus, focus of this panel discussion is on the importance of arbitration in the energy sector and to critically analyze the issues arising on the substantive and procedural fronts, along with existing and potential nature of disputes in the energy sector. We will, over the next 80 minutes, like to espouse the panel's expert views from the experiential learnings. The panel discussion will be conducted in 2 rounds. Initially, I will be inviting the panelists to give their comments or a statement with regard to the subject under discussion today. And thereafter, I will be posing questions to the panelists in the second round. May I now invite Justice Raveendran to start with his statement.
Thank you, Jatinder. This is a technical subject, but it involves considerable amount of expertise on arbitration also. Now, we are all aware of the advantages or supposed advantages of arbitration. That is, it avoids technical rules of evidence, it avoids procedural technicalities, it results in a binding decision which is not open to question except certain permitted grounds. Most importantly, it gives the choice to have specialists or technical experts as adjudicators who can appreciate and understand the technical issues and provide practical decisions, cut costs, gives choice in regard to venue, and provide a non-hostile atmosphere. With all these advantages, arbitration should be highly popular. Why is it that there are complaints? I will only read 2 paras on my article on arbitration, which deals with this subject. I quote, "In spite of these advantages, there has been dissatisfaction about the manner of functioning of Indian arbitrations in some quarters of the corporate world. There is also a prevalent impression that arbitrations conducted abroad, particularly in London and Singapore, are completed promptly in a more professional manner, and that most of the arbitrations held in India, whether international or domestic, are time-consuming, expensive, and lack professionalism. The grievance frequently aired is that the arbitrators and advocates do not show a sense of urgency to complete arbitration proceedings. In some states, there is also a sense of frustration and helplessness among parties on account of what is seen as excessive intervention by courts. No doubt, the arbitrations held in London and Singapore may be conducted promptly and professionally, but it is difficult to agree with the view that arbitrations conducted in India are qualitatively inferior or lack professionalism. Nor is there any justification for an arbitration between 2 Indian parties governed by Indian law being conducted abroad, either on the ground of better efficiency or on the ground of speedier resolution. It is rather depressing to see contracts which are to be performed in India, entered in India by Indian entities with other Indian entrepreneurs, providing that Indian law would be the substantive law governing the contract, but the seat of arbitration would be outside India, normally London or Singapore. The Indian arbitrators and lawyers are in no way inferior to their counterparts abroad. If there are any perceived deficiencies in Indian arbitrations due to certain factors, the remedy is not to take arbitrations out of India, but for all stakeholders to put their heads together and take effective steps to make arbitration more efficient and effective in India. I thought that this will focus on the arbitration part. Thank you. Thank you, Mr. Chief.
Thank you. May I invite Ms. Arora to share her opening comments.
Good evening. Your topic is very interesting, relating to the energy contracts, energy laws, and coupled with that, with an arbitration. Now, many of us would know here that these energy contracts are very, very special in their domain. So far as production sharing contracts, joint operating agreements, the gas pipeline agreements, they require special expertise. So when we bring about arbitration with respect to these contracts, there is a huge need to build a pool of, let me say, professionals who have knowledge and specialization with respect to this particular very technical field. That's one thing that comes to my mind straight away as an opening thing that I would like to say. Secondly, because these contracts can involve a large number of very large technical issues, and therefore that technical knowledge is very, very important, and therefore developing a bar as well as judges or technical professionals who have that knowledge to be arbitrators, and this would go a long way so far as the energy contracts is concerned. I say this from some degree of past experience, which is rather very long ago, when I used to do production sharing contracts and operating agreements. And I remember from that time that how much technicality was involved in this. But having said that, now if I've changed my focus to the arbitration, I thought that I will just pitch myself today on the aspect of public policy and arbitration. I chose this particular topic because, as you say, public policy is an unruly horse, and an unruly horse that can drive away everything, including can take your arbitration awards to a completely different trend of being enforced, to be implemented, and etc. So I'll just be very brief then, if I can make this as my opening part today, to say how we develop public policy law in India, trace a small amount of history, and to show that between 1889 to 2021, it's still an unruly horse, dangerous to ride. And while we have kind of bridled it some bit in 2021 within our amendment of subsequent amendments in the law, but there are certain areas still which leave your arbitration awards in a realm of public policy debate when it comes to an enforcement. So very, very briefly, if I may say so, public policy came to be first interjected in the Indian Arbitration Act in 1899, when they said for the first time that an award can be set aside for an arbitrator's misconduct or where an arbitration or an award was improperly procured. Subsequently, the CPC of 1908 came. Now, why I'm tracing this history is for a reason. Let's not believe that public policy is a thing just now of a present. It's been there for such a long time. And where are we headed with this? And I think some may call it a full circle, but I will call it a circus when I conclude this and where we have brought it to just now. So in 1908, CPC came in with a schedule at that time, and which said that an award could be remitted to an arbitrator on an objection to the legality of an award, which is apparent on the face of it. But in 1923 came the judgment of the Privy Council in Chamsibara. This judgment then has held the field for a very long time, and even today we rely upon it. And it was so succinct to say that award can be set aside if there was an error in the proposition of law incorporated in and appearing on the face of the award. And that is where Chamsibara left it, and it held the field for many, many years, and we followed it. Now, in terms of speaking as a word public policy, the Arbitration Protocol and Convention Act of 1937 put in the word public policy for the first time in its section 7, and it said that a foreign award would not be enforced if it was contrary to the public policy or laws of India. After that, then came the Foreign Awards Recognition and Enforcement Act of 1961, which went on to say that award would not be enforced if such enforcement would be contrary to the public policy of India. While I'm reading this, just keep in mind that each one of your contracts, which are energy contracts in an international domain, and where a state may be a necessary party, let us take for an example, a production sharing contract or something like that, where you have a profit sharing with the state. Just imagine the public policy of India is an issue that you are going to face when you're going to be enforcing your awards. So just keep that larger perspective in mind as you just take this and see how this has panned out. So 9 comes in then the 1940 Act, which repealed our 1899 Act and also the Schedule 11 to the CPC at that point in time. But the courts still narrowly construed the grounds of a challenge for an error apparent on the face of the record, and they limited these grounds to barely 4. They said, misconduct of an arbitrator or proceeding, award has been made after an arbitration proceedings have become invalid or they have been superseded, or an award is improperly procured, or otherwise invalid. Now, the last one was a little wide, but our courts did till some time construe this very narrowly, although this was not a very satisfactory act, but then that is how it was. Now, here, while public policy was not a basis for setting aside an award, nevertheless, the misconduct by an arbitrator was a ground to set aside an award. And this was premised on a rationale that an arbitrator was bound to act in accordance with public policy, principles of administrative law, failure to consider material evidence of fact, consideration of irrelevant facts, so on and so forth, over a period of time emerged as a ground of challenge under the 1940 Act. So now you can see virtually the whole pan, was open to challenge a particular award. Comes in the 1996 Act. In 1996 Act, Section 48, in Part 2, conferred a right on a party to object to an enforcement of a New York Convention for an award on a ground that its enforcement would be contrary to public policy of India. So we specifically on foreign awards brought in this particular act. Now, it is important here to just pause for one moment and see how have we construed a public policy. The understanding of a public policy goes back to an old judgment of 1959, which was Gherumal Pare, where Supreme Court went on to say that public policy connotes some matter which concerns the public good, public interest, ideas, and so on and so forth. So, the entire thing was completely ambivalent. What public good, public interest, public ideas, etc. This, however, then you would confine it still maybe into certain silos there. But subsequently, in 1974, in a subsequent judgment in Muralidhar and Agarwal, the Supreme Court said that, well, Gherumal, those are limited, but, you can always enlarge the heads of public policy. You can keep on enlarging the heads of public policy, so you kind of just broaden the aspect of a public policy thereafter. But when it came to arbitrations, the Supreme Court applied public policy to enforcement of foreign awards on the ground that an enforcement would be in conflict with the public policy of India. That was Renu Sagar. In Renu Sagar, the Supreme Court held that public policy would mean a doctrine of public policy as applied by the courts in India and international public policy. It adopted a very narrow view, and which was in accordance with the model law and the New York Convention. And this is very important because now Renu Sagar is 1994. And as I will go on in very few minutes, I'll conclude this. You would find that by 2020, we would have gone a huge circle and come back to Renu Sagar with the amendments in 2018. So, we are kind of going all around, and we really need to focus on where we are headed onto this aspect in allowing challenges to the foreign awards, or even for that matter, the domestic awards. So then, and Renu Sagar, the Supreme Court just said that what would you take is fundamental policy of Indian law, contrary to fundamental policy of Indian law. It said a thing which is today now no longer available, which is interest of India, and justice or morality. So it culled out the three heads, and this was Renu Sagar in 1994. The enforcement of awards had to be in, conflict with the public policy, and it was not the award itself which was in conflict with the public policy. So the effect of enforcing that award had to be in conflict with the public policy of India, but not the award itself. And that was a very interesting principle that Renu Sagar did call out. This narrow view prevailed until saw pipes came about. And saw pipes then expanded the aspect of public policy extremely, followed by a judgment by the Supreme Court in McDermott. Now, in McDermott, rather than to limit public policy as expounded in saw pipes, it went ahead and actually expanded the scope and created new heads of public policy that where the reasons given were vitiated by perversity in evidence or an award was vitiated by internal conflicts, etc., etc. So the approach to a public policy became very, very wide. This now brought about the pre-2015 situation, because we had the amendment then in the law in 2015 and 18 to put this whole back, and we are just coming to the closed chapter, or a circus as I call it, between the time of Renu Sagar or pre and to go back and take it there. Pre-2015, associate builders put down our heads of challenges to the award in 5 limited domains, or let me say they're actually quite wide, but those were the heads under which you could challenge these awards, and the award may not be enforced there. Fundamental policy, which include compliance with statutes, binding judgments, judicial approach, natural justice, Wensbury principles. Perverse or irrationality. Number 2, interest of India. Number 3, justice and morality. Number 4, patent illegality, and making of an award induced or affected by fraud or corruption. But this was pre-2015 amendment. Followed the 2015 amendment in our act, and we're trying to bring, as far as I see, the act somewhere to a center of the line on this interferences by the courts on myriad grounds, purportedly under various heads, and by in turn also public policy. The 2015 Act did few things. The amendment said that the award, public policy, would be only on the following circumstances. Now let's just list them out, and there were only 3 there. Making of an award was induced or affected by fraud or corruption or violation of section 75 or 81 of the Arbitration Act. Now just look, we are going back to what the law was originally way back in 1894. This was one of the grounds under which you could have challenged then. So, you're bringing it back on a neater circle. Contravention of fundamental policy of India, conflict with most basic notions of morality and justice. 20 years later, which is after Renu Sagar, the same principles came to be now brought in through a legislative mean by an amendment to the Arbitration Act. One thing that went out of this was clearly the Wensbury principles were now no longer a good ground. So the latest that we have now is the Sangyong judgment of the Supreme Court. While the aforesaid facts the court has recognized, but the court has included one, which is patent illegality. When you include patent illegality, remember the patent illegality brings into its domain also perversity. When you bring in perversity also, you open another huge domain for a challenge. So today, as it is understood, the courts in India will not interfere with the merits of an award, except when there is violation of natural justice. Wensbury principles are no longer a ground of challenge anymore. Public policy will now mean, in respect of domestic awards, as it's against the fundamental policy of India. Now, interest of India, which was there in Renu Sagar, is no longer opting for a ground for challenging. Justice and morality now mean the most basic notions of morality and justice. And patent illegality stays as a ground of challenge. So we have gone around a whole circle, let me say at least in 20 years since Renu Sagar. And if I go back to how I traced it from 1899, we almost came back to where we had started on the whole thing. But when it comes to your enforcement of an award that arises out of large contracts, energy contracts, stakes are high, values are high, long drawn, may not be a long drawn arbitration, but they are expensive. The arbitration process itself is expensive. There's also a need to have a clarity when it comes to enforcement of the awards, a need to have a structured method in which the awards are being enforced. Apart from the fact there is an immense need to have people who are technically qualified to be arbitrators and to deal with these particular contracts is my view. Thank you so much.
May I now invite Mr. Francis Xavier to make his initial statement and comment.
Thank you, Jatinder. Now, I'll be brief. I think the first thing I want to say is Singapore has been home to quite a number of energy disputes. Roughly, my estimate would be about 10 to 15% of the disputes that we see here would be energy-related disputes. And, you know, Jatinder, as you've pointed out, by and large, the bulk of the disputes are resolved through arbitration, as the latest 2021 Queen Mary study shows. 90% of respondents favor arbitration, either as a standalone or coupled with ADR. And but you know, it is with great interest that I heard Judge Raveendran's comments about the complaints about arbitration in India, because the complaint that arbitration is taking too long and is costing too much is not just a problem in India, it's a problem across the world. Jurists and users across the world complain that arbitration is not delivering on its promise as being a speedy and cost-efficient method of dispute resolution. And so, as Jay, as you pointed out, there is an increasing recourse to the international commercial courts. In Singapore, the international commercial courts that were formed in 2015 have seen brisk business, and a fair amount of the energy disputes in particular have gone to the SICC for the quality of the world-class judges, the very active, hands-on, proactive case management by the judges throughout the life of the dispute. And so we are actually seeing that quite a number of the SICC disputes are being resolved faster than the average arbitration. But obviously, because of other considerations that has been pointed out by the panelists, including confidentiality, global enforcement of awards, arbitration is still, by far the most popular game in town. Now, of course, as I think Meenakshi has also noted, the bulk of the energy-related disputes are very complex, very protracted. And so it is important, I think, for the users that arbitration counsel and arbitrators, and this is something that Samir mentioned right at the start, that arbitration is costly and it's not quite as fast as one would expect. And so it behoves the arbitration community to really, make their best efforts in every case to make arbitration speedier and more efficient, to ditch long-drawn discovery battles and to get on with it, right? And we hope that arbitration will continue to, be the preferred choice for energy-related disputes. And I'm sure the popularity of courts in London, in Singapore, the international commercial courts will continue to gain ascendancy. But I think in the long run, the bulk of the disputes will still be resolved by arbitration because of the flexibility of being able to appoint a number of the points that has been covered by Judge Raveendran and Meenakshi. Thank you, Jay. Back to you.
Thank you, Francis. Now, from the industry perspective, may I invite Mr. Jalundhwala, who is head legal at Adani Enterprises, to kindly make his comments.
Yeah. Good evening to all. Thanks, Mr. Cheema. I think today's subject, which has been selected, is a very important subject, that is future of energy and arbitration in India. In a lighter way, I must say, the future of energy, arbitration, and India are quite bright and remarkable. With this, let me give my opening remarks on the subject. India's latest energy development goals include affordable access, increased sustainability, better safety, and economic integrity. The energy sector is a critical to our way of life, as well as a way of our success. China and India together are expected to consume more than half of the world's energy production, and the rest of Asia continues to require significant resources. India has been welcoming of private sector investment and the introduction of hydrocarbon exploration and licensing policy in 2016, followed by the open acreage licensing policy 2017, have played a important role, pivotal role in taking the sector forward. Energy disputes. What is the energy disputes? Energy disputes often involve complex and controversial issues relating to security, sovereignty, and public welfare. The construct and design of the contracts in this sector are unique and complex in its own way, given the involvement of large players and no single universal legal system in place. Additional factors like political landscape, environmental regulations, and geographical events also bring about challenges to this sector. There is no denying that disputes across the energy sector continue to demonstrate and dominate international arbitration, both in number and value, with the highest value arbiter awards in history arising from energy-related arbitration. Arbitration of this type of disputes in the energy sector in India has had a mixed record so far. It is not the only mechanism adopted, as contracts frequently provides incorporate a multi-tiered dispute resolution process, which may provide for the amicable negotiations, mediation, or conciliation as a prerequisite to any arbitration proceedings. It is also common for certain categories of disputes to be referred to expert determination rather than to arbitration, because energy sector is a very specialized sector, and where sometimes we need the expertise on that particular sector to resolve the issue. However, the most significant disputes are typically resolved by recourse to arbitration rather than the alternative of domestic court litigations. The disputes span across all the sectors, including LNG, hydrogen, geothermal power, hydropower, nuclear, oil and gas, solar, and wind energy. All these disputes across need the arbitration as a tool for dispute resolution. With the onset of the rapid investment, disputes over profit sharing, price revisions, cost analysis, quality and quantity of energy products, transportation and storage of hydrocarbons, engineering, all this will persist between the entities. Energy corporates are facing increased levels of scrutiny due to environmental impact, policy, and political regime changes, consequently leading to potential disputes. The energy sector wins hands down the competition for highest value commercial arbitrations. I can give you some examples as an opening remark for such type of disputes, say like profit sharing disputes, issues of cost and profit in petroleum and their allocation were contested in Reliance Industries and Union of India, as well as Union of India versus Videocon Industries Limited. Similarly, operational disputes were there, and which is a important and very important case is related to operational disputes is in Nico Resources Limited versus Gujarat State Petroleum. Nico and the Gujarat State Petroleum were joint venture partners, and they were engaged in Hazira gas field activities. And the field gas production began to decline in 2006. And as a result, the operator was unable to meet its obligation. Nico and GSPC has entered into a balancing gas agreement to help in filing this shortfall. Due to inability of this Nico to do so, due to change in policy, GSPC invoked arbitration, which has run for a number of years. Similarly, taxation disputes, you all know about the Can Energy dispute, I may not go into deep into that, but later on the Indian government has paid some amount to Can Energy, that is around 7,900 crores to settle the respective dispute. Thus, the ways preferred for resolving the dispute in energy sector in India are same as in other countries. It is a welcome step by the present government to choose a method for fast redressal of disputes in energy sector. And for that, in July 2019, Indian government decided to make a committee. The Ministry of New and Renewable Energy issued an order for setting up a dispute resolution mechanism to handle unforeseen disputes between solar or wind power developers and Solar Energy Corporation of India, that is in called a abbreviation called SECI. In March 2022, finally the committee has been set up to evaluate issues pertaining to extension of time due to force majeure event, extension of not covered under the terms of the contract, and all disputes other than those pertaining to extension of time. So now, as far as the energy sector is concerned, even that particular they are also trying to have the dispute resolution by way of a preferred mechanism, that is an arbitration. That is, I want to tell as far as my opening remarks is concerned. Over to Mr. Cheema. Thank you.
Thank you, Mr. Jalundhwala. May I now invite Mr. Khan. He represents an institution which has just been born a few months back, International Center Arbitration and Mediation Center at Hyderabad. He serves the institution as its registrar. I welcome him to make his opening remarks.
Thank you, Mr. Cheema. Thank you for inviting me. And it was really lovely to hear the views of the experts who are very senior to me. And it was, I think most of the part they have already covered. But there are a few things that I'd like to add. One is that why in these disputes concerning energy sector is arbitration preferred. I was going through the ICC report of 2020 and also the exit report. What I saw was there was a large number of energy disputes which were being resolved in these institutions. So that clearly shows that international arbitration has been helping these energy sector grow and progress and become mature. Same we have seen in Europe. It started in 1980. I'll come to that later, but one of the reasons why parties prefer, because these disputes generally involve an international element. The reason is that confidentiality is a major reason. Other reasons obviously include that disputes are very complex, huge stakes are involved, but certain trade secrets, IPR related issues, sensitive information is why parties do not want it to be a subject matter of a court, and it should not be out in the public because there are competitors. So they like to keep it confidential, and that's one reason why international arbitration helps. The other reason is neutrality. Investors have a feeling that if we go to the local courts of the country, then local courts will have certain, some kind of bias in favor of the local entities. And that's why they prefer a neutral forum. So neutrality is maintained in arbitration, and that's one reason why they prefer going to arbitration and not local courts. Enforcement, of course, was another reason quoted by Mr. Xavier. That's another reason. But there are a couple of issues with international arbitration. One of the most important issue, which I have seen, I've handled a couple of energy arbitrations. One is regarding consolidation of arbitration proceedings, because what happens is that multiple contracts are entered into between the same parties for various reasons, maybe the supplies from different sites. Now, what parties do that when they're drafting these contracts, some of the provisions are not incorporated in each and every contract. Now, what happens is when you invoke arbitration and you have to rely on certain provisions, which is helping you, which is saving you, some of these contracts will not have that provision. And another reason is that consolidation becomes a problem because either the institution does not provide for the correct provisions or effective provisions for consolidation, or the parties do not consent. As a result, there are multiple forums in which the case is going on. Some of the cases may be filed in different courts, and some may be going before an arbitral tribunal. Another issue is regarding the arbitrability of such disputes. Imagine if there is a joint venture, which is very common in such kind of disputes. Now, what happens is if the issue is pertaining to damages, then arbitrator, of course, can very well assess those damages and, pass an award. But what if there is a deadlock between the JV, the joint venture partners? What if there is an issue of insolvency? Or what if a party is simply claiming termination or asking for a specific performance? Now, in such cases, the question pertaining to arbitrability also rises. And another reason why arbitration in such matters is having a lot of issues internationally is because sometimes tribunal do not appoint experts. If I take example of India, there is a provision, section 26, which says that you can appoint an expert in any dispute. Now, I think it's one of the most underused provision by arbitrators. And what we have seen is party appointed independent experts. Now, they're called independent experts, but the problem is that you don't really bite the hand that feeds you. So the issue is that it creates more confusion because there are two experts on different sides saying something opposite. Now, which part and who should the tribunal trust? So I think that's one other reason which I think is quite problematic. Lastly, because I'll keep it short, I'll not take too much time. Two other things which I wanted to mention is that the policy decisions by the government affect these contracts. And I've seen that, policy changes brought in by the government have impacted investment also in the state. And it gives rise to a lot of dispute because these are all long-term contracts. The pricing cannot be finalized. Now, what happens is if there is a renewal of the pricing for various reasons, that market is being affected. And little, per unit, if the pricing is, changing even with few dollars, then it can result into $1 million claim. So that's one reason that price review has been an issue. It was introduced in Europe in 1980s. And for 2 decades, I think Europe was struggling, but I think now Asia is becoming the new Europe because Asia has some largest importers of LNG like Japan, China, and South Korea. So I think what we can do is we can learn from Europe and grow and mature using international arbitration. Thank you.
Thank you, Mr. Khan. I think Justice Raveendran, Mr. Arora, I think now Mr. Khan has also alluded. I think we all agree that there is an imperative need to induct technical members and include testimonies of expert witnesses to navigate the labyrinth of energy disputes, especially for purposes of quantification of damages and ascertainment of certain causes of action, etc. My question is to Ms. Arora and to Mr. Khan both. Mr. Khan, from the perspective of the institution, what are we doing about it in terms of bringing expert witnesses and expert testimonies? And Ms. Arora, if you would like to comment on it. Thank you.
Ma'am, would you like to answer first?
I have already started by saying that where you have specialized contracts, particularly of this nature, be it technology, be it energy, whatever, there is sometimes an immense need to have expert, whether you call it an expert evidence. And as you said, it can be that the arbitral tribunal can appoint an expert, but the fact is what I have seen in my experiences that sometimes the arbitral tribunal are even resistant to having an expert evidence which is being eluded by one of the parties, or bringing in an expert only to explain to them that there is a methodology for calculation of certain compensations, damages, or how you will calculate the loss, because necessarily the arbitrators are not expert. But there has been a reluctance and resistance to allow that, which I think it is quite damaging, because arbitrators, not being experts, should allow or should encourage that to come at right conclusions, right awards there. Yours, Mr. Khan.
Sure. Thank you, ma'am. So, sir, so far as our institution is concerned, what we have done is we have been very flexible about it. We do not really want to explain the whole procedure, that what should be the procedure with expert witnesses, with the testimony, you should go for hot tubbing of witnesses, or you should use the traditional method. We really do not want that we should be dictating these terms in the rules, because idea is to make it flexible, and the discretion should be exercised by the arbitrator as well as by the parties, keeping in mind the nature of the dispute. The idea is because each and every arbitrator has a different mindset, like rightly pointed by Meenakshi ma'am, that some arbitrators may have a different, because in my personal view, I feel that it's always better to have an expert on the panel because in one matter, what we have seen recently, which has been referred to us by the Supreme Court, that 2 arbitrators have been appointed and the 3rd arbitrator has to be an expert. Both the parties have to give 5 names each. So I think some panel of that nature is the best solution to this. Because what happens is when you have an independent expert, even by the tribunal, the problem is that there is too much of reliance on that expert report. In some cases, as a counsel, what I have seen, that the award was in a way a reproduction of the whole expert report. And on the basis of that report, the award has been passed. Now, the issue is that, is it not in some way being, delegating your authority to make a decision? And too much reliance on this report, because our arbitrator at the end of the day may not have that expertise. So I personally feel that the best solution to this is, when you are having an arbitral tribunal, it's always better to have experts on the panel itself, rather than having any independent experts assist the tribunal. And I personally feel that party appointed experts do not really help much to the arbitrator in arriving at a conclusion. Thank you.
Would anybody else like to comment on this?
Jatinder.
Yes, sir.
Yes. For example, if you go to LCIA, when you are giving your biodata, you have to say in which area you have a specialization. For example, in regard to energy field itself, they have oil and gas, they have power and energy, they have energy pricing. Similarly, in infrastructure, in other matters, an arbitrator discloses his specialization, which helps in selecting appropriate arbitrators. But in India, we do not have a system of selection of specialists, for the simple reason we do not have specialists. Most of the arbitrators in India are retired judges. If you go to London, if you go to Singapore, most of the arbitrators are Queen's Counsel, experienced Queen's Counsel, who have handled special types of litigation and therefore have secured domain knowledge. And when they act as arbitrator, they are able to use it. Now, we should develop in that area. Until we develop it, until we have our own experts. Experts does not mean a technical person. Even a senior counsel or a judge can be an expert, provided he develops domain knowledge. And that will be supplemented by, an expert appointed by the parties or expert appointed by the tribunal itself to assist the court. Because like technical persons will be good in technical matters, they may not be good in adjudication of rights and obligations. Therefore, as you rightly pointed out, 2 kinds of mixes are possible. It is possible that both parties appoint technical parties and they appoint as a presiding arbitrator a judicial person with adjudicatory background. Or it can be vice versa also. The parties may appoint persons like senior counsel or judges who have adjudicatory experience, but these 2 appoint a technical person so that he can supply the technical aspect. This is one thing. Another thing is, our arbitrators do not take the trouble of getting domain knowledge when they are appointed as a particular arbitrator in particular field. No, they start learning in the process of the conducting the arbitration, which is very injurious to that arbitration. They should have basic knowledge. I would suggest if lawyers or judges should act as arbitrators in a field where they do not have experience, before entering the arbitration, before the first hearing, they should have undergo some kind of refresher course so that they don't waste the time of the parties, valuable money of which is paid for the hearings. By this process, I think Indian arbitration can improve and serve special areas like energy. Thank you.
So thank you for your comment. I think it's really valuable input for the arbitration community in India. Francis, just as Raveendran had mentioned Singapore, if you would like to also elucidate what are the processes in Singapore in terms of expert testimonies and expert arbitrators?
Yeah, I mean, Jatinder, yeah, I mean, the experience in Singapore is that, as Judge Raveendran says, the most important quality of the arbitral panel is their ability to carry out the adjudicatory function. So, and so that's not to say, you know, as Tariq has said, Madam Arora has also emphasized, it's important for the arbitral panel to have domain expertise. So it is the case that we would appoint, in Singapore, the predominant practice is to appoint a panel who has domain expertise, you know. So they could have been counsel practicing in the energy area. They, you know, they obviously have had domain knowledge in order to become arbitrators. But I think by and large, there is a reluctance to appoint, especially as the, say, the presiding arbitrator, someone who's only technically trained, but is not legally trained. Because the idea is that the president many times carries out a very key role in making the call in terms of the adjudicatory function, you know. So if the tribunal, the wing arbitrators are tied one way and one the other way, it's a president who then decides based on the composite legal and technical and factual scenario what should be the, where the award should point towards. So I've not seen a panel in my years of experience where you have a president who's a pure technical expert and who is not a legal or adjudicatory expert. And so when you have, as Judge Raveendran and Tariq has said, when you have arbitrators who are domain experts, and then they can be greatly assisted by experts, even party appointed experts who are then hot tubbed, you know. And I'm sure Judge Raveendran and others here would have had experience in real life court cases or in arbitrations in that regard. Back to you, Jay.
Thank you. Thank you. Thank you very much. I'm now going to turn to Mr. Jalundhwala. I have two questions clubbed in one. What kind of issues as an energy company you confront typically in terms of in the arbitration space? And the second question for you is, as a large corporate house and as a legal head of such an institution, what are your expectations from the dispute resolution system as a key stakeholder?
Right. Yeah, first of all, what you are saying is what kind of issues energy company are confronting with. Let me start with India. India is one of the world's fastest growing economies with rising urbanization and expanding middle class. The country will account for about 25% of the rise in global energy use by 2040 and have record growth in energy demand over the next several decades. To start with, the recent parliamentary reports says that India needs around INR 2.61 trillion to achieve its target of 175 gigawatts of renewable power by 2022 or 23, but is facing financial challenges. Keeping in line with the requirements of the climate change, the way it is happening in India and across globe, Indian market is moving towards renewable resources to attract vast volumes of institutional and private capital. The most important challenge for future scaling of renewables in India is the poor financial condition of power distribution companies, most of which are owned by the state governments. Almost all the renewable energy is purchased by such discoms, resulting in very long and unsustainable payment system and payment cycle. The primary issues in some of the industries within the energy sectors, let me give some examples. One of the most important is the what Justice Raveendran sir and others have said about the fuel availability. In today, every day in newspaper, we are seeing that the coal is not available. Even from some 25th May onwards, some of the passenger trains are likely to be converted into goods train for transporting the coal from X place to Y place. So thermal capacity addition is facing this problem by the growing fuel availability concern. Coal supplies by Coal India Limited is restricted to around 50%, I can say, of the actual coal requirement by coal-based thermal plants. And this leads to the import of coal to continue and run the plant 24 hours, which increase to the cost of the import and cost to the fuel cost. That is one. Secondly, contractual disputes, because you know the PPA which has been executed with the DISCOMs are about for 25 years or so. And there are so many contractual disputes which are arising out of that. Major thermal and renewable entities face contractual disputes due to non-establishment of payment security by procurer. You know, procurer has to provide the payment security, which they are not providing, and that creates a dispute. Or most of the times delay in the payments of the power bills and invocation of change in law provisions. I must tell about the change in law provisions. You all know I do not have to explain that change in law provisions, but whenever there is a change in any law and which impacts the company, in that case, the company can recover that amount from the state utility also. As far as India's system is concerned, what happens when there is a change in law event happens? As a company, we have to approach to the commission, either CRC or any other regional commission. And we have to file a petition. And thereafter, it went up to the Supreme Court. It goes up to the Supreme Court and takes number of years. We at Adani have been involved in various such litigations because we are a largest power producer, I can say, as far as the private sector is concerned. And various such litigations for recovery of payments from the state utilities that get triggered due to change in law provisions. Unfortunately, the way I have told you, the multiple number of forums and matters being adjudicated up to the Supreme Court level, it takes about 7 to 8 years to reach the finality. And actual change in law effect, which we are getting, is after 7 to 8 years. And thereafter, what happens? Okay, we have to ask for the carrying cost, that is interest on the change in law impact. So this also burdens to the state utility. Similarly, as far as thermal renewables, what I've said, same way the oil and gas sector, which is also energy one, their approval is the one of the issues which everyone is facing. We are also in the gas, CNG, PNG. The city gas distribution development is not a one-time job, but rather a continuous process of network establishment and expansion over a very long period. There is a huge dependency on obtaining clearances, NOCs, permits from local authorities and agencies, which is quite time consuming, and different methods are followed. There is a need, there should be a single window clearance. And for smooth rollout of the infrastructure, which is user-friendly and shall be easy to understand and follow, monitor, and shall be time-bound. There is one provision which has been introduced under the PNG, oil and gas sector, is levy of predetermined penalties. This amended CGD authorization regulations, which stipulate the levy of penalties annually for the shortfall of the domestic connections. Because if I have committed, I will put so much connections in a particular year and I'm not doing, that is a shortfall, that has been encashed by them, or that has been taken away by them by way of encashment of the performance bank guarantee of the entity in a unilateral manner, I must say. While this may seem easy to the regulator, But as far as the company is concerned, as far as the corporate is concerned, what happens? It is very difficult for them to get the bank guarantee, because the bankers and financial institutions are saying that when we are giving the bank guarantee, it is one-sided, it will be encashed without even referring to us. Similarly, a pipeline infrastructure development. It's also a very important challenge, I can say, across India, because a particular geographical area we are developing and we have to go to another geographical area, then the pipeline infrastructure development, installation of the pipelines is a very important issue, because a lot of litigation take place. Similarly, if you see power generation and distribution, the distribution takes place through transmission, and the transmission lines are going from X place to Y place, say about 500 kilometers down the line. In that case, what happens? It passes through various villages and the farms and everything. So many disputes have been faced, even though there is a framework given by the government and framework given by the law, but so many disputes arise, and which always being a hindrance for putting the transmission lines. All this has been faced, and therefore there is a strong need to push for wide-scale implementation of private-public partnership models. This is what I thought, these are my thoughts as far as the power sector, oil and gas sector, what we are facing today. And the government, as far as Indian government is concerned, they are trying to make it more and more easy and easy to do business. And that particular results we are enjoying over a period of time, we will enjoy over a period of time. Thank you, Mr. Cheema.
Thank you, Mr. Jalundhwala. Turning to Francis. Francis, could you share your experiences in the energy-related arbitration with respect to interim and the emergency relief, which is the SIAC Rule 30? Just share your past experiences.
Right. Thank you. I mean, that emergency provision has been very popular. As you know, Jatinder, SIAC was the first Asian institute to introduce emergency provisions, which was then followed by very closely by ICC, for instance. 2 years later, in 2012, Singapore introduced it in 2010. Now, this has been very popular. In 2021, we've had 15 cases where emergency arbitrator provisions were relied upon. Since 2010, that brings the number of emergency arbitrator applications to 129. So this has been very useful, because with the emergency arbitrator provisions in force, before the constitution of the arbitral tribunal, if a party goes to court for an SIAC arbitration to seek an injunction, the court will invariably say, why aren't you having recourse to the emergency arbitrator provisions? And so emergency arbitrator provisions has been very popular for all sorts of relief. And in the energy sector, it has been key, in preventing someone from evicting you unfairly from the premises of the plant, from calling on a bond related to the agreement and the project, and various other issues. So it has been a very useful tool in Singapore-based arbitrations, in order to preserve the status quo. And it is very speedy. So the average time frame, I've acted as emergency arbitrator in a number of situations. The average time frame is 8 to 10 days, you get an order. And sometimes even within 2 days. So it has been very popular, Jatinder, and it has been one of a very useful mechanism for immediate relief prior to the appointment of the tribunal.
I'm going to ask Mr. Khan to comment on this as well. And what changes do you intend to bring to the institutional framework in aid to making India the arbitration hub?
So far as emergency arbitrations are concerned, the recent approach taken by the Delhi High Court and also by the Supreme Court in Amazon, what we have seen is that Indian courts are in fact taking a very pro-arbitration stance. We are recognizing emergency arbitrators. And there was a recent judgment where Delhi High Court in fact refused to entertain a Section 9 application because the emergency arbitrator had dismissed, and that was under the Japan Arbitration Center rules. But there is an anomaly because, institutional rules also cannot preclude a court because it has its limitation. because there are certain cases where there's a third party involved. And these are exceptional cases, of course. The rule is to go for emergency arbitrator. But in some cases, when you're seeking a relief in respect of a third party, which is not a signatory to an arbitration agreement, in that case, whether an emergency arbitrator will be able to pass an order against that particular party, that is one thing which Indian courts have to look at. That situation has not arisen, but maybe that in that case, Section 9 can be a useful forum. But what Indian courts, I'm hoping, and what we have seen, I think there's a very progressive approach in this regard, that they have refused to entertain Section 9 applications when a party has already availed or elected a remedy under the institutional rules, that is emergency arbitration. And in fact, our rules also at IAMC provide proper provisions that we are also capable of passing relief within a period of 10 days or 2 weeks. And as per our rules, the registrar, in consultation with the governing council, has to appoint an emergency arbitrator if required in a 3-day period. So I completely agree with Mr. Xavier. That's a very, very good and popular option which is open. Apart from that, the other changes which I think which we should look at is that, in Section 11, courts should appoint some arbitral institutions to appoint arbitrators, because there has been dependency in Section 11 applications. And recently this issue was brought in before the Supreme Court. And the Supreme Court has asked that a report has to be filed by the High Courts regarding the status of Section 11. And apart from that, I think that we also need to do some kind of trainings, and awareness should be generated that the government should take policy decisions keeping in mind the interest of the investors as well as interest of the public. So I think that is one thing we should look at. And at the end of the day, what Justice Raveendran rightly said, that we all have to come together, the judiciary, the legislature, stakeholders, we all have to be on the same page and have a same vision, because one wrong step by any of the stakeholders would take us 10 steps back. So I think that's my take on this.
I would just add to what Mr. Khan has said. This emergency arbitration is going to improve the quality and quantity of institutional arbitrations, because in ad hoc arbitrations, this kind of emergency arbitration is not possible. But in institutional arbitration, it is possible. The Arbitration Act has been amended to encourage institutional arbitration. Institutional arbitration, it is hoped, will cut down delay, cut down cost, bring down professionalism. Added to it, if we have the provisions for emergency arbitrations, as the Hyderabad International Arbitration Center has, and I am sure the Mumbai International Arbitration Center also must be having, and if it becomes a part of the process, then it is like you go to a court and seek an injunction. Like that, it becomes a part of the process and people get accustomed to it. The relief can be quicker and better. Thank you. Thank you. Thank you.
Thank you, sir. Meenakshi, would you like to comment on Amazon versus?
I think there is so much that is already said, and I think that's exactly as Justice Raveendran said, and also Mr. Khan said, is the underlying premise of Amazon judgment of the Supreme Court. That is, you unclog the court and there is a party autonomy. Once the parties have decided to take an institutional arbitration, they take everything that goes with it, including the emergency process. And why should then it be referred to a court? And that's exactly also one of the bases on which Amazon proceeds there. And I think it's a completely a step in the right direction, because the courts are not able to cater to the speed that you require at that stage to grant an interim reliefs, which may be required in contracts or arbitrations of these. The courts are not geared for it very often. And therefore, I think that in that direction, yes, there is a huge scope and a potential in institutional arbitrations, which provide for such emergency arbitration.
Jatinder, can I just add this? And that's a very good point that Meenakshi makes, because, when you need an injunction in 1 or 2 days, and in this complex energy arbitrations, and that's a point I think both Tariq and Judge Raveendran as well as Jatin alluded to, domain, and this is a point you made, right? Domain expertise is so important. So if you have a judge who is a commercial or trade dispute judge listening to an injunction in a very complex energy case, he's not going to have the time to read up on the background to come up to speed in 1 or 2 days. It's impossible. So that's why when you have an emergency arbitrator that an institutional arbitral institution appoints, someone with domain knowledge, they are up to speed very, very rapidly. Back to you, Jatinder.
Very well said.
We are in the final 10 minutes of our discussion today. So coming back to you, Francis, what are the typical challenges? And, I would feel everybody to pitch in whatever they wish to make a comment about, because these are sort of last comments that we're inviting from the panel. The typical challenges you have confronted representing clients who are either developing an energy project or an infrastructure project, or who have developed a project in Southeast Asia, Singapore jurisdictions.
Well, I think, Jatinder, you've just put a keen finger on the pulse of the problem, right? When you have regular contractual disputes, there's already complaints that the process is not expedient. This, people are getting bogged down with nitty-gritty technical fights. And so when you get to an energy dispute, which is very complicated, it involves, because this area is highly regulated. So you will have regulations and national laws of several countries colliding with each other. You have the need, as many of you have pointed out, the need for expertise, domain expertise in a number of areas, quantum, technical, engineering, price. And so you have a very protracted, very complex, huge amount of documentation. If you don't have the rigor to get it done efficiently, then this is going to take forever, and you're going to get bogged down in all sorts of skirmishes, technical, legal, and so on, right? And so it's very important that the arbitrators and arbitration council have a very enlightened view about things like discovery, about fights over lists of issues, agreed lists of issues, about what is really necessary and what is not, because otherwise your arbitration is going to take 3 times or 4 times as long as it should. So it becomes very important that all the mechanisms of case and time management is applied very diligently, and so you need experienced arbitrators and enlightened counsel. Back to you, Jay.
A quick comment, Mr. Khan.
So in my experience, the issues that I've seen, one issue I'll point out. So there was a clause in the agreement regarding the change in price, which I was mentioning earlier also, and that has been an issue because these are all long-term contracts. What Mr. Jatin also rightly pointed, that 25 years is a time in some contracts, it's even longer. But the issue is that there was a reference to a policy, public policy, that any change in policy will affect the pricing also. Now the government came up with a circular with a notification wherein it was mentioned that the pricing would be applicable retrospectively also, and the prices were increased. Now this was challenged in a writ court. Now the petition in writ was pending for a very long time. The arbitration was ongoing. Now the issue is that the arbitrator was appointed ad hoc. So one is that arbitrator did not have the technical knowledge. There were 5 different contracts, and each of them having different clauses. This particular clause was not present in all 5. So now whether in which contract this complexity of the case. And the third issue was that the arbitrator at the end of the day is dependent on the writ, because what will be the outcome of the writ court and what is remaining for the arbitrator to do, because it completely depends on the outcome of the writ, and accordingly the arbitrator at best can ascertain certain damages. But ascertaining damages also in such cases is very difficult. It is not easy. So it's that's why they are too much dependent on experts to come and evaluate what would have been the pricing of the gas at that time and how it would impact. So all of these issues I think are there, and these are some common issues that I have come across.
Raveendran, any comments for the audience?
Okay. As the time is coming to a close, let me refer to something which has been on my mind with reference to arbitration. You know, when recently the Supreme Court rendered its judgment in PASL versus GE, saying that two Indian parties, in regard to a cause of action that arose in India, governed by Indian law, can choose a foreign seat. It is not opposed to or in violation of Section 23 and 28 of the Contract Act and the consequences. Now, I would think that this is something that recognizes and encourages party autonomy. I would think it is a right step in what the government is trying to do, that is make arbitration friendly, investor friendly thing, and also to invest, to attract investments. Various steps are being taken. This is one good step. But there is a slight murmur in one section, that section being the members of the arbitration bar. We don't have a full-fledged arbitration bar. Still, we do have some kind of arbitration bar. And the arbitrating judges, that will this take away the pricey, big arbitrations from India to foreign jurisdiction, thereby denying that kind of work to Indian lawyers and Indian arbitrators. I have only one question to those people who are saying or who are finding fault with the judgment in GE. This one question, I would like to leave you with that. Why is it that Indian parties, two Indian parties, entering into a contract subject to Indian law in regard to a cause of action in India, is trying to go out of India for an arbitration? Why is this question not being asked? Why is it that the question is whether the decision of the Justice Nariman's 3-member bench is right or wrong? My take on this is, the question need not be and should not be about the decision. The question should be about the fundamental question, why parties are entering into such agreement. If all of you, the members of the bar, the arbitrators, all stakeholders, courts, if you give better service to the litigant public, the disputants, and they will stick to India. That is the way we should function. Instead of finding fault with the judgment, let us all, the arbitrators, the members of the bar, give better service to the trade and industry, so that not only the Indians stick to India, the litigants from other countries should come to India. That should be our, I think, goal. And I'm sure that such discussions will help in giving not only from the energy sector, but other sectors also, to get arbitrations to India. Thank you.
Meenakshi, a quick comment from you.
All right, just half a minute.
Yes.
I think I completely agree with what Justice Raveendran said. If our arbitrators would choose to have more dates back to back, choose to finish an arbitration within a period of specified time, and not have to exchange their diaries and spend half a session in only finding common dates, we would be much better off. I may be a bull in the China shop, but I believe in speaking my mind.
And the lawyers don't ask for evening dates and Saturdays.
Yes, I completely agree with that. So we need a dedicated arbitrators, and who would do one arbitration in a day, maybe the 2 sessions. We have to stop this exercise of 2 or 3 arbitrations in a given day, or just 2 hours. It does not work. And the next dates come after a very long time. You've lost the link. You are trying to refresh. You're going back and forth. It takes too much of time. I think it needs a correction, both in our institutional arbitrations that are happening in India, as well as in the ad hoc arbitrations. I just leave it there. I'm sorry if that's a little bit too sharp, but then that is...
No, that is needed.
Mr. Jalundhwala, final comments?
Finally, I have a comments about the expectations of the corporate house from the dispute resolution system as a key stakeholder. Let me tell you what corporate wants. One is that key clarity, stability, and faith in adjudication process. That is the first part. Second part, all panelists have already said, which is very important, the good pool of the arbitrators, judges, and counsels with having in-depth technical knowledge on this subject, which is very much required, because otherwise the arbitration is going towards the law side only. Then third is the realistic and executable schedules, timelines, and plan for delays and disruptions. Finally, one of the important point is the effective case management techniques, which has to be lack thereof creates an issue. Our Indian system provides, as you all know, say Supreme Court retired judges giving the award. Suppose I'm in Gujarat and in Ahmedabad, and this Supreme Court retired judges are giving the award. If it is in my favor and it's against other party, then it has to go to the district court. This is the biggest challenge, because when an arbitrators who are of a particular stature and they are giving the award, I think a system has to be changed, whether it has to be directly to the High Court or somewhere else. Secondly, there is a leader of 34, 37 and Supreme Court. Then one person who is getting an award, to get the money, it takes not less than 5 years. So that system needs to be changed. This is my final comments as a corporate house.
Over to Samir. Thank you very much. It's been absolute delight to be a moderator for this panel with such legal luminaries, with such valuable inputs. Thank you, Justice Raveendran, Ms. Arora, Mr. Xavier, Mr. Jalundhwala, Mr. Khan, and thank you to Mr. Kochhar and Rohan for hosting us this evening. And over to you, Samir.
Well, thank you very much. I'm grateful to you all for your sagacious participation and so many good ideas that you've given. Jay, I leave you with the onerous task of bringing this together as a recommendation paper that we could possibly send back to all the stakeholders. Thank you very much for joining us this evening, and look forward to see you again soon. Bye.
Thank you. Thank you very much.